My name is Michael Young, and I'm a lawyer who handles contested estates in Texas. And one of the common concepts that we deal with in Texas estates is the notion of community property. And it often comes up in estate contests because it means that a spouse may have certain rights to assets in a estate regardless of what the will says. A common example may be a husband passes away and there may be a blended family and he leaves all of his assets in the will to his children. Well, does that mean that the spouse is left nothing? No, absolutely not, because the spouse still owns her share of the community property. And community property in Texas is generally all property that's obtained during the marriage. It's considered community property. Now, separate property is generally property that one of the spouses obtained before the marriage. And there's some important concepts there. The first being that separate property does not become mutated into community property just because one of the spouses contributed something to it. And generally, community property does not become separate property. It's called the inception of title rule. The nature of the property, whether it's community or separate, is established at the time of the marriage. Now, this can be a very important concept in estates because, as I discussed, one spouse cannot disinherit the other spouse of their community property. But sometimes it takes some work to figure out whether a piece of property was community or separate. With land, it's generally not too hard because you can search the deed history. I had a recent case where the surviving spouse was acting like all this property was her. She had an interest in community property until I looked up the deed history and I saw that the deceased husband had been deeded that property by his father's estate, by the executor of his father's estate, well before that. And in that case, it was during the marriage, but one of the exceptions to community property is property that's one of the spouses receives via an inheritance or via a gift. That's one of the few exceptions. And there's a few other exceptions that I may get into in some other videos. But the point being is it's important to consult with an attorney who has experience evaluating community versus separate property, and also evaluating the presumption under Texas law that if you can't show something is separate property, then the courts are going to presume that it's community property. If you're involved in a contested estate in Texas, give me a call.